Based on existing precedent, Stephanie's claim isn't strong enough under the tort in Wilkinson and Downton. She would claim under the tort of intentional infliction of physical harm or psychiatric injury. As Stephanie's reaction does not fulfill any recognised psychiatric injury, the emotional distress she suffers is not sufficient grounds for her to claim upon. It is clear from A, the tangible harm that Stephanie undergoes, and B, the severe extent of Michael's actions, and C, the parallels that this case has with that of Wilkinson and Downton, that there is a clear gap left by Wilkinson and Downton. This clear gap and the nuances created by the aforementioned case would be remedied by a new tort, the intentional infliction of emotional distress. The new tort can be broken down into three key elements: the intention, the infliction, and the emotional distress. When considered in this manner, the tort appears in the case of O and A. O and A breaks the intentional infliction of harm into three different elements: the conduct, the mental, and the consequence elements. Establishing the conduct element, Michael's actions directly mirror that of Downton's, thereby they are automatically inferred to fulfill the conduct element. Moreover, although Michael may argue that his statement was simply a joke between friends, Lord Justice Smith, regarding false statements in general, suggests that a false statement is uttered with the intention that it is believed, thereby negating the argument that Michael's statement was simply a joke. Moreover, when considering O and A, the conduct element requires a legitimate interest. The falsehood of the statement, the manner in which it was expressed, and the relationship between the three individuals suggest Michael's actions had no legitimate interest, and his interest may have even been inferred to have been considered malicious. This swiftly brings us on to our next element, the mental element or intention. Lord Justice Stuart Smith's comments upon the false statements, that Michael's statements were uttered with the intention that they were believed and with the intention to cause a reaction as they were a joke, suggests that there was a clear intention from the joke and from the fact that he uttered the statement at all to cause a reaction. Moreover, the defendant's conduct and his relationship with Stephanie suggests that the intention can be imputed upon him. However, Lord Hoffman states that when considering mere distress, imputed intention is not sufficient, especially when there is no psychiatric injury. Therefore, a new tort is required to fill this gap, whereby intention can be considered as part of the tort in and as of itself. When there is a genuine intention to cause distress, as Lord Hoffman also states, Lord Hoffman also states that a genuine intention to cause distress should be considered when the tort in question is emotional distress. Lord Neuberger states in the dissenting view that strengthens this proposition: when there is an intention to create severe distress, as is the case with Michael, that alone can establish the tort in principle. Lord Hoffman also highlights the disparity between intentional and negligent torts, arguing that the threshold set for negligent claims is much lower than that of intentional torts. This is counterintuitive at best and absurd at worst, considering the fact that intentional torts have such a high threshold as opposed to negligent torts. Therefore, the test for intention should be based on that set by Wilkinson and Downton. In any case, Michael would satisfy the tests and satisfy both the conduct and the mental element and the first half of the newly proposed tort. All that remains is the consequence element, the emotional distress. In OPO and MLA, physical harm, including psychiatric injury, but not mere alarm on OPO and MLA covers physical harm, including psychiatric injury. However, mere distress and alarm are not covered under that tort. Furthermore, in Rothwell and Chemical Insulating Co., emotional distress cannot constitute a claim unless it amounts to a medically recognized illness. The facts of this case are similar to the facts in the case of Wilkinson and Downton. However, the harm suffered was not to as severe a degree as Miss Wilkinson's. The tort is not sufficient grounds for Stephanie, but Stephanie has still suffered a tangible level of harm. This tangible level of harm must still be remedied and would be done so through the intentional infliction of emotional distress. And this remedy is necessary as it is the very basis upon what the justice system is set upon, especially that of the law of torts. This is evident from Chief Justice Holt's statement highlighting the essence of law and the law of torts itself. Every man that is injured ought to have his recompense. In this case, Stephanie's injury requires a certain degree of recompense. Moreover, the internationally recognized Diagnostic and Statistical Manual of Mental Disorders state there is no clearly defined diagnostic boundaries separating recognized medical illness and other forms of mental disturbance. The Law Commission report also states there is no clear distinction between mental distress and symptoms of recognized psychiatric illness. They give the example of post-traumatic stress disorder patients. Certain people who had come in close contact to post-traumatic stressful and other such cases who fail to meet the criteria of post-traumatic stress disorder but still required the same level of care and harm and still showed certain symptoms that were similar to those who were diagnosed with PTSD. Justice Dixon in Bunyan and Jordan also suggests that someone suffering from neurasthenia had sustained sufficient injury to claim under the Wilkinson tort. However, it is important to mention that neurasthenia is not only not unrecognized by the DSM, but it is also applicable to a variety of conditions and symptoms. Similarly, in Wong and Parkside, even though Wong was repeatedly harassed, emotional distress was not sufficient grounds to claim upon. Although the Harassment Act may better protect the claimant, the case instantiates the fact that the tort of Wilkinson has stagnated and requires evolution and reform. Justice Hogan comments on the lack of evolution of tort law in accommodating these misdemeanors, purely because there is no medical injury attributed to the harm that these individuals have suffered. Overall, there is no denying the fact that these individuals had suffered a sufficient degree of harm. This sufficient degree of harm, as of yet, has no remedy and is not redressed by the law, purely because it is not recognized as a psychiatric injury. Therefore, this new tort, the intentional infliction of emotional distress, would cover those that have suffered tangible harm that is quantifiable and at the expense of someone else who has intentionally committed these actions. Overall, the courts must consider this new tort as it will broaden the horizons and it will broaden the scope of the law of torts and allow for the law of torts to assist vulnerable individuals like Stephanie, and with this tort in place, Stephanie would have a much stronger case. Where all the elements of the tort are fulfilled to a sufficient degree, the tort facilitates a wider range of wrongs and allows for a wider range of victims to be sufficiently satisfied with the law. And with that, the intentional infliction of emotional distress must be considered and brought to light as a evolution on Wilkinson and Downton and the remaining laws that have reformed Wilkinson and Downton, but not to a great enough degree that Stephanie would benefit.